Finally, on the legal side, there's some really, really bad social media lawyering going on out there. I will not get into all of the nonsensical stuff that I see as an attorney myself since 1994. But as these 5 lawsuits continue to unfold, a lot of people are either trying to jump to certain legal conclusions well before the evidence justifies those conclusions, or in some cases, they're just making up nonsense, assumedly for clicks or viewers or whatever other things the grifters and the con artists of the media world do in sports and in many other contexts. For example, there are people I assume are not attorneys suggesting that because Article 3, Section 2 of the United States Constitution, because of that text, they're suggesting that the appropriate venue for the FSU ACC lawsuit is the United States Supreme Court. This is a patently ridiculous idea, and I will not get into all of the reasons why, but here's a quick primer. There are 2 basic ways to get your case all the way to the United States Supreme Court. One, through a very, very long and typically extremely expensive multi-year appeals process after multiple decisions in lower courts, where the ACC lawsuits are right now, right? Lower courts in North Carolina, lower courts in South Carolina, lower courts in Florida. And even then, if you work your way through up the system, the United States Supreme Court takes only a tiny percentage of the cases it is asked to hear on appeal. The only other way, there is no door number 3. There is no third road to the top of the mountain. There's just 2. The only other way to get your case in front of the 9 justices on the United States Supreme Court is to request what's called original jurisdiction. This means that the facts of the case are so unusual that they fit into this tiny, very, very, very narrow category of cases that can be heard by only the United States Supreme Court. The classic example of this is when one state is suing another state. For example, New York and New Jersey are neighbors, right? They are connected to one another. There's actually a famous case. It's called New York v. New Jersey, state v. state. In those very rare situations, the case actually goes immediately to the United States Supreme Court because the Constitution says that's the appropriate forum when the parties are 2 or more different states. It's not just the right jurisdiction, it's the original jurisdiction in those narrow sets of facts. The problem here, of course, is that only one side of the lawsuit is an extension of the state government here. Yes, Florida State University, as a public university, is considered an extension of the state of Florida for these purposes. Same with Clemson in the state of South Carolina. However, the Atlantic Coast Conference is not and has not been an extension of any government. It is a private entity. It is not a governmental actor. It is not an extension of any state government. That means original jurisdiction in front of the United States Supreme Court is inappropriate for these cases and simply not supported by legal precedent. As attorneys, we're trained to say never, but I don't see a shred of evidence suggesting that the United States Supreme Court should take this case on the grounds of original jurisdiction.